La période de questions.
Honourable Senators, question period is over. Delayed answer.
Orders of the day, ordre du jour. Sénatrice Gagné.
Senator Gagné. Thank you, Madam Speaker. Honourable Senators, pursuant to the order adopted December 7th, 2021, I would like to inform the Senate that question period with the Honourable Ginette Petitpas-Taylor, PC, MP, Official Languages and Minister responsible for the Atlantic Canada Opportunities Agency will take place on Wednesday, May 11th, 2022 at the end of routine proceedings or 2:30 p.m.
Government business, affaires du gouvernement.
Bill, second reading, projet de loi deuxième lecture, number 1, S-7, numéro 1, S-7.
Resuming debate, Senator Wells.
Thank you, Speaker. Senators, I rise today to speak on Bill S-7, an act to amend the Customs Act and the Preclearance Act of 2016. In my remarks today, I will address several issues related to this bill. First, I think it's important to review the government's rationale for the legislation and to understand that this bill has come to Parliament very late, with the result that there is a legal gap in Canada's border enforcement. Secondly, I want to touch on some of the serious questions and challenges that arise from certain provisions of this bill. Finally, I'd like to comment about the way in which the legislation has been brought forward and what, I think, this reveals about the very serious problem we have with the government's reactive approach to policymaking. Unfortunately, colleagues, this bill fits a pattern. The pattern is that of a government that is both highly reactive in its policymaking and extremely slow in its policy implementation. First, let me address government's arguments in relation to the purpose of the bill. The government's arguments were presented by Senator Boniface here last week. In her remarks, Senator Boniface reviewed the fact that Bill S-7 arises from a decision rendered by the Alberta Court of Appeal in October of 2020, finding that examination procedures used by the Canada Border Services Agency when it comes to the content of personal digital devices was unconstitutional. These devices were, until recently, examined under the terms of paragraph 99, bracket 1, bracket A of the Customs Act. The Court's reason for striking down this provision of the Act in relation to personal digital devices was that the Act itself imposed no limits on such examinations. For many years, CBSA officers have been using Section 99, bracket 1, bracket A of the Customs Act and its definition of the, quote, goods to incorporate personal digital devices. As Senator Boniface pointed out, digital devices have the ability to hold documents which might contain an individual's entire life history and include the most private information about any person. The Court of Appeal found that although persons crossing international borders must have a lower expectation of privacy than is normal in a free and democratic society, the scope of information that border officers have access to when examining personal digital devices suggests that some reasonable limits are required. Senator Boniface quoted the Court of Appeal decision as follows, quote, "We are mindful that protecting the privacy interests in an individual's personal electronic devices while recognizing the need for effective border security will involve a complex and delicate balancing process. It will be up to Parliament, should it choose to do so, to devise a new approach that imposes reasonable limits on the ability to conduct the searches at the border." Closed quote. Colleagues, this is what we're doing today with this bill. While the Court referenced the fact that Parliament must decide whether it wishes to enact a law on this matter, the reality of our political system is that it is up to government to bring forward legislation to address the legal gap that has resulted from the Court of Appeal's decision. In this regard, we should be under no illusion that we do now indeed have a significant legal gap. That's because although the decision of the Alberta Court of Appeal is only applicable to Alberta, the Ontario Superior Court has now also ruled that the same section of the Customs Act is unconstitutional, thereby extending this legal limbo to Ontario. Colleagues, here I think it's important to note that the nature of the cases that triggered these rulings in both Alberta and Ontario. Each of these cases involved the importation of child pornography. I know that every senator in this chamber will agree that these offences are among the most disgusting and dangerous crimes which can be perpetrated. They are also crimes which prey upon the most vulnerable and innocent in our society. In her remarks, Senator Boniface stated, quote, "It is imperative that we take this incongruity seriously in the meantime. I implore you, colleagues, not as the sponsor of this bill, but someone who was involved in law enforcement for a long time, to prioritize Bill S-7 for our consideration. We can't let this incongruity stand for a day longer than necessary for two reasons. First, training modules can't occur for CBSA officers until the finalized version and the finalized wording of the bill passes through Parliament. Second, and most importantly, each day that passes from here on out, can be used by those actors seeking to import obscene materials such as child pornography into Canada." Close quote. Naturally, I agree with that, colleagues. I think we all do. However, I must point out that the court gave the government 18 months to respond to its ruling. It initially gave the government 12 months, and then it extended it for another 6 months. Yet we now have a situation where Senator Boniface first spoke to the bill on behalf of the government on the very day that the court's extension of the provisions of Section 99, Bracket 1, Bracket A of the Customs Act expired. How could this happen? In fact, I approached Senator Gold 2 days prior, noting that the expiry was on our doorstep. And colleagues, I'm just the critic. In my view, there is no excuse for this. There is particularly no excuse for this, given the fact that what the government is now proposing to legislate in Bill S-7 is, to use Senator Boniface's own words, already being done. What Bill S-7 does is take the previous internal policies of CBSA when it comes to the examination of personal digital devices and proposes to put them into law. Somehow, doing this took 18 months and counting. In relation to this, I again want to quote the Alberta Court of Appeal. Quote, "We are mindful that protecting the privacy interests in an individual's personal electronic devices while recognizing the need for effective border security will involve a complex and delicate balancing process." Closed quote. There is not any complex and delicate balancing process at all in Bill S-7. Instead, what we have is merely a cut and paste of the existing internal policy of CBSA into law. That's what I was told by in the departmental briefing and in the critics' briefing. This is extremely unfortunate because there are very serious privacy concerns which are at play here, and I will highlight a few. First, there are the legal criteria that will be used to justify the initiation of an exam of a personal digital device. The threshold of that will be, there must be a reasonable general concern. That's a quote, colleagues, a reasonable general concern. CBSA briefing notes state that a reasonable general concern could be triggered by a multiplicity of indicators, or such a concern could be triggered by one more significant indicator. No specific contravention is required. The concern need only relate to a contravention of legislation related to the import or export of goods. This means that the term, quote, reasonable general concern, could in fact mean almost anything. Each of those words, reasonable, general, and concern, are the lowest possible bar you can come up with. If a CBSA officer said a traveller looked nervous, that would be grounds for a full search of a device, not just for the bad guys, but for every Canadian who is subject to a secondary search. During debate last week, our colleague Senator Bussin stated that, quote, "It worries me that this bill will create difficulties for border officers to search questionable personal digital devices," close quote. Yet our colleague Senator Simon stated, quote, "I'm worried that might open the door for searches that are more aggressive than they were under the regime of regulations that border agents were using beforehand," closed quote. And in fact, colleagues, it wasn't even under regulation. It was simply policy, and there were no controls or protections for Canadians whatsoever. Senator Omadvar stated, if a reasonable general concern is to be triggered by the behavior that a border officer notices, that is hugely subjective, closed quote. I would agree with that, since it is made all the more subjective because the triggers could be multiple indicators which are not defined for us, or they could be a single indicator, again, not defined. Or as one of our colleagues correctly stated in the briefing, it could be a racial profiling. It could be nothing. Colleagues, if a Canadian is pulled in for a secondary search, it could be for no valid reason. I think what is contributing to the confusion is the fact that, as Senator Simons correctly argued, that there is no precedent in Canadian law for the legal use of the term reasonable general concern. The government has rejected the idea of employing the more familiar legal term of reasonable grounds to suspect, arguing that this term is not appropriate for the border context. Here I think we need to understand the specific legal arguments. The fact that the Alberta Court of Appeal apparently declined to impose a threshold of reasonable grounds to suspect in its ruling may support that argument. But what we need to understand as legislators is precisely why that is the case and why the simple codification of CBSA's policy is the best approach. We have had no explanation from the government on that very important point, and the question was asked directly to them. So we can't really be sure about the term reasonable general concern actually means. As I said earlier, he looked nervous, could be enough. This issue will be examined in committee if we were to conform with the court's guidance to, quote, devise a new approach that imposes reasonable limits on the ability to conduct such searches at the border, close quote. Reasonable limits, colleagues. Reasonable limits, the court said. And reasonable general concern is, in fact, no limits. I believe that government has actually not engaged in such an exercise in drafting this bill, having pulled it directly from their policy. So it will be up to Parliament, it is up to us, colleagues, to fill the void, all the while operating under the pressure of the gap in law that the government has created by waiting more than 18 months. In relation to the examination of personal digital devices at the border, there are fundamental questions as to how exactly officers will perform these examinations. We are told that the examinations will be determined by regulations which we have not seen and will not create. Colleagues, as you know, legislation, like S-7, allows regulations to be made, but we will not have a say in those regulations because our role is simply to make the law that permits regulations to be made. So it's our duty to ensure fairness to Canadians in the question of searches while permitting the necessary searches to take place where warranted. And this must be greater than reasonable general concern. In relation to these regulations, the government has indicated just two things. First, that when the officers examine personal digital devices, they'll be obligated to take notes during such examinations. And second, that these examinations will be limited to material that is present or stored on devices at the time that an individual is crossing the border. At this point, we know very little about the tangible protection that note-taking will provide and how the limits imposed on material that a border officer may examine on a personal digital device will be governed. Will it include simple links to a website or files stored on the cloud, which of course would not be resident on a digital device? What we want in this context is to provide border officers with sufficient capacity to intercept obscene or otherwise illegal materials, but at the same time give Canadians the assurance that their privacy will not be compromised where there are absolutely no grounds. That is the balance we have to strike. In that context, and we have been told, I was told in the critics briefing, that CBSA officers that search a personal digital device must first turn off mobile connectivity, commonly called put in airplane mode, so that there is no access to material that might be simply accessed via the web and not stored on the device. Colleagues, if it's stored if it is stored and accessible on the device, fair game. Indeed, that's what I was told. And colleague, a personal story here. I was stopped at the border a number of years back. In fact, I in filling out the customs form, I said I had $1,000 worth of goods. I knew the limit was $800, so I went in and said I'd like to pay the taxes and duties on the additional amount. So I went in for secondary search. They asked for my phone. I gave them my phone. They asked me to unlock it. I unlocked it. They searched through my visa statements. So I wasn't aware of the policy. I wasn't aware of the policy, and of course I have no reason to be aware of policy. Ignorance of the law is no excuse, but not ignorance of CBSA policy. And so the CBSA officer went through my visa statements. Where did you buy this? What is this? What's this charge? So that violation of my privacy, I wasn't told that I had the right to, well, they didn't tell me that they had to turn it into airplane mode, of course, which they didn't do. And I don't think they do it in the majority, perhaps all of the cases. I asked Senator Boniface after her speech whether it would be appropriate for CBSA officers to also advise travelers to shut down their connectivity. Of course, I wasn't advised. This might improve the confidence of travelers that their privacy was being protected, but also ensure that illegal material stored on the device was accessible by CBSA officers. Senator Boniface suggested that we look into this at our committee study, and I believe that we need to do just that, because that is a critical element. We need to be sure that the regulatory process will be transparent and provide Canadians with the assurances that they're entitled to. There are other questions on the provisions of this bill that need to be asked. One of the measures incorporated in the bill is a decrease in the maximum fine for interfering with a CBSA officer conducting such a search. And colleagues, this is proposed in the bill to drop from $50,000 to $10,000 for a summary conviction, and $500,000 to $50,000 for an indictable conviction. For an indictable offense. I'm not sure how significant reduction in fines for child porn smuggling serves to protect children that are subject to these heinous abuses. In fact, I'm not sure what this provision has to do with any of the purposes of this bill. Colleagues, if anything, offenses for crimes such as this should be stronger, not weaker. In the Senate, we have witnessed a pattern on numerous bills which have come before us with sudden proclaimed urgency, often arising from last-minute panic associated with poorly thought-out measures or looming deadlines. Colleagues, we saw it more than a year ago on the bill for offshore health and safety. The government had 5 years to implement offshore health and safety regulations. They sought 2 additional years and were granted it in a Budget Implementation Act. And then in Senator Ravalli's bill, which was obviously introduced in the Senate, they sought 2 more years, and we said, no, you do it in 1 year. And that was passed unanimously in committee, in this chamber, and in the other place. And we are clearly seeing that in relation to this bill, the looming deadline, in fact, the deadline that's passed. I've not heard any argument that such an approach was unavoidable in this case. I don't want to get too far off topic, but colleagues, we have become used to this occurring, that many of us scarcely blinked when we learned that, oh, by the way, today is the deadline. 18 months ago, the Alberta Court of Appeal signaled that it expected a very different approach from the government. To reiterate, the court said, quote, "We are mindful that protecting the privacy interest in an individual's personal electronic devices while recognizing the need for effective border security will involve a complex and delicate balancing process." Close quote. Colleagues, I couldn't agree more. It now falls to us in Parliament to, as the court said, devise an approach that imposes limits on the conduct of searches at the border, but at the same time ensures that our border is protected. Colleagues, we've seen that this cannot include loose definitions such as reasonable general concern that has no basis in Canadian law and even less so in practice. Thank you, colleagues.
I see many senators wanting to ask you questions, Senator Wells. We still have 26 minutes. So do you accept to answer questions?
I will take the 26 minutes if there are that many, and then I will ask for 5 more if there are more.
Senator Bovey, followed by Senator Motion, followed Senator Boniface. Senator Boniface, did I see you? Yes. Senator Boniface, Senator Motion, and Senator Bussin. Yes?
Okay. Thank you, Senator Wells. I think you raised some important questions, particularly around timing, and I share some concerns, those similar concerns in terms of this bill. You also didn't mention, but I think you're aware that it was denied going to the Supreme Court. So what it leaves for customs officers is inconsistencies across the country. And I think it's so, from my perspective, important to have a pan-Canadian perspective, one that we can make well known to our U.S. counterparts and others. So while we are frustrated, perhaps, with the speed with which the bill was put before the Senate, on the other side, for the purpose of those officers trying to do the work, would agree with me that we should do a thorough review, but we should not slow it down intentionally because of our displeasure with the government.
Senator Wells.
Thank you, Senator Boniface. This won't be slowed down by anyone near me or who might be advised by me. I think this needs to be done as soon as possible and with the correct rigor that protects Canadians.
Senator Boniface, Senator Motion.
Thank you, Your Honour. Senator Wells, you did speak a little bit about the airplane mode. Now, I don't know if your phone is different from mine, but you know, just putting airplane mode is just a flick of the finger and airplane mode is on. But the border patrollers can also unflick and the airplane mode is gone and it can go through your phone. So you didn't touch a lot on this, and I'd like to hear you on this as critic of the bill.
Senator Wells.
You, Senator Motion, and you're correct. It's easy to do. Unlocking a phone is easy to do, the facial scan or on some the thumbprint or simply the password. From my understanding, and I think it was in Senator Boniface's second reading speech and indeed in one of the briefings, one of the two briefings that I had from department officials, you're required to give your password to unlock the phone. That's a requirement. If you choose to not give the password, then Border Security, CBSA, has the right to hold the phone and unlock it in whatever ways they unlock their phones. But they told me that their policy was that they would not. They said give it. I can't remember the exact term. I call it airplane mode. And yes, it's easy to take it off that. But their policy was to only search it in non-connectivity mode. If they do that, then obviously they'd be violating their own policy, as they did in my case. In fact, I didn't even put it in airplane mode because I didn't know that was my choice. So I think that's a fundamental right that Canadians have, to be told they have a choice. Certainly, if it's under policy, if it's under law, then they may not have that right. But you're right. It's taking it off airplane mode is simple. But their policy, and this is what they told me, is that their searches can only be conducted without connectivity. So I agree. It's very simple. But if their rule or their policy or their standard procedure, or perhaps if we make an amendment in the bill, perhaps it'll be in law that they have to tell, and I think that would be an amendment that would be worthy of consideration for the protection of the rights of Canadians.
Senator Bussin.
Thank you, Madam Chair. Senator Wells, when you gave your speech with regard to this legislation, you talked about the delay that the government put forward, and also talked about, and I think you used the words despicable and disgusting to talk about some of the crimes that we're talking about here today. It goes without saying, and I think the law of better late than never might apply in this case. But wouldn't you agree that although you say there is a difficult balance to be found, that with the principle of better late than never, that this legislation ought to be forwarded immediately to the committee, that they can look and discuss and debate this balance, accepting that in the gap are, as you called them, innocent victims that are the subject of this whole discussion?
Senator Wells.
Thank you, Senator Buston. You make an excellent point. This needs to be law as quickly as possible. I mean, I don't want to say it could have been done 18 months ago. It should have been done long before now, and I see no reason to delay the process of sending it to committee. Obviously, we all have a right to speak on it, and that could take time. I don't know of any of my colleagues that sit with my caucus are going to be speaking on it. I don't think so. I haven't been given any indication, but I think let's get it to committee. Let's give it the scrutiny that it deserves. It's an important issue. It's not something trite. It's something where it's a serious issue that worst case scenarios happen. So I have no reason to want it delayed or to see it delayed.
Supplemental, Senator Buston?
Supplemental, Senator Wells. You discussed the issue around having your iPhone searched in the past, and they found some visa records. I would like you to comment on whether you felt absolutely violated when they found these visa records in your iPhone, and how you feel sometimes when they go through your entire luggage.
Senator Wells.
Senator Buston, I live a boring life. So while I did feel some violation of my privacy, and it's my bank statements, I do my banking on my phone. So there was that feeling of violation, but I also thought, well, this is the process that a free country has. And I also had nothing to hide. In fact, on the claims form. I said I have higher than the amount. I don't. In a public position such as ours, we don't need to sneak around and try to get around the law, because the headline isn't some guy gets around the law. It's senator gets around the law or tries to get around. So yes, I did feel a violation years ago. In the 70s, I had a car and it was parked in my driveway, and the door was locked. And got up in the morning, and my car had been broken into, and my cassettes had been stolen. They weren't 8-tracks, Senator Simons. They were just the regular old-fashioned cassettes. And a couple of weeks later, I came out to my car again, and one of the cassettes was on the seat, the passenger seat. So they had returned one of the cassettes. Hang on, that may be true. That's when I felt violated. Not the first time for sure, but that's when I felt violated, when I thought it was targeted with a specific act for nothing that had reasonable grounds. They didn't come to steal anything. They already did that. So the violation that I felt was when there was no reasonable grounds to do it, and I think that's the crux of this debate.
They couldn't find a player.
Dupuis.
Senator Dupuis.
Senator Toulajan, Senator Midbar.
Merci, Madame la. Thank you, Madam Speaker. Would Senator Wells accept another question? Senator Dupuis, go ahead and ask your question. Thank you. Senator Wells, in your speech you said that there was a new criterion introduced in Bill S-7, and that is the case. Now, you also mentioned other interventions by senators in the chamber that reproach this bill for having a new concept. But wouldn't you say that the study you wish to see done in committee, and I think it is important to have that study done in committee, shouldn't deal with the issue of it being a new concept? That isn't the problem, because the Court of Appeal itself introduced it. When the Court of Appeal says that the existing concept may be too severe for the circumstances we wish to cover, and you legislators may come up with a milder one that creates fewer obligations for the border services agents, officers. So it's not about the fact that it's a new concept. What we should study is whether this concept that has been developed by the government under its bill is appropriate, legally speaking, given the circumstances we're trying to cover. So it's not that we shouldn't be creating scarecrows for nothing. New concepts are included in bills all the time. Isn't it rather an issue of whether or not the concept chosen by the government is appropriate in the context that this bill is dealing with? Senator Wells.
Concept chosen by the, and you're right, that's what the Court of Appeal said. So the new concept chosen by the government is reasonable general concern, and that's what I have issue with, because reasonable general concern, to me, there's no limit to what, there's no trigger to what might trigger a search. There's no trigger to what might trigger a search. So we're supposed to be given comfort by the fact that we're told, oh, they'll take notes. They'll take notes. Well, the notes will be there to protect CBSA for sure. They won't be there to protect the individual, in my opinion. They'll say, look, you know, the person looked nervous, or, you know, he didn't appear that he was from Canada, or, you know, whatever. He was sweating and fidgety. I think that the bar of reasonable general concern, which is exactly as you said, that's the new concept presented by the government, which I guess follows advice from CBSA. That bar is too low for the protection of the individual privacy rights that every law-abiding Canadian should be afforded.
Senator Simons.
Would the Senator take a question?
Senator Simons.
Thank you very much. My question relates, it's so difficult to talk about issues of child pornography because it is such a grotesque and exploitative crime. And online child sexual abuse is a scourge in Canada that I think that there's no one in this chamber who is in favor of it. What I'm concerned about is a question of balance and volume. Every day in this country, thousands of pieces of child pornography are bought and sold and traded online. The amount of child pornography available online is practically infinite. Yet, over the last 5 years, from May 5th, 2017 to May 5th, 2022, Canada Border Services seized 392 examples of child pornography at the border that came in on digital media, whether some on cellular phones and computers, but others on USB sticks, on hard drives, on CDs, DVDs, that kind of thing. So that's 392 seizures in 5 years, not all of which are on phones and computers. Probably the minority are on phones and computers, I'm not sure. It just seems to me that we are potentially breaching the civil liberties of every international traveler for the sake of stopping a very, very small hole in the dike, while over here, millions of pieces of child pornography are coming over the internet. So I just wanted you to tell me whether you think the abridgment of our civil liberties is sufficiently balanced given the minute amount of child pornography that is actually being detected in this way.
Wells.
Simon's excellent question. So in the old days, you wanted to import child pornography, which we all agree is heinous. You'd have it in a folder or a binder or an album or a magazine or something like that. But now, you're right, the vast, and I can't say vast enough, the vast majority is stored not on pages of a book. They're stored online, in the cloud, in attachments to things only accessible through the internet. There is a way to stop people coming across our border with images that we're talking about stored on their digital devices. That's search everyone and give CBSA the right to have full access to all of the devices. We know that's not reasonable. It's like saying we know we can stop car accidents on the highway by having a 5 km/h speed limit. It's not practical. So I think that the the liberties that we have, that right to privacy, which is fundamental to our society, fundamental in Canada, that right to privacy it's a strong one. The need to stop this material coming across the border, that's also strong. But you're right, it's a finger in the dike, because you can put your finger in the dike and the water's flowing over the top of it, and that's what's happening. I don't think it's unreasonable, or I think it's reasonable that Canadians, and I'm really just thinking about Canadians coming in, not others. That's obviously it's an important concern, but it's not as strong as concern that I have for the rights of Canadians to privacy. So I think, striking that balance is important, but not the lowest bar possible that has been called reasonable general concern. So you make an excellent point. We're looking at the nickels and dimes when there's the dollars flowing in. Thank you.
Senator Atoulejan, followed by Senator Omidvar, followed by Senator Richards.
Thank you, Speaker. Senator Wells, did you know that even if you have your phone on aeroplane mode, if you don't have the location on, they'll know exactly where you've gone and how long you spent at various locations?
Senator Wells.
Senator Atoulejan, thank you for your question. So yes, I know a lot of that's tracked and stored. I know a lot of what all of we do geographically is tracked and stored. So having it on airplane mode or non-connectivity, if that's the policy, and I think it's a reasonable policy, then where you might have gone, of course, you have to declare where you're coming from, and it may seem obvious from your boarding pass. So I'm aware that there's other information that can be gathered from your personal devices without connectivity.
Omidvar.
Thank you, Speaker. Will Senator Wells take another question?
Of course, Senator Omidvar.
Senator Wells, in truth, I should have asked this question to the sponsor of the bill, but I missed my time, and I'm forgetting exactly what happened. But perhaps you can help me understand this. With these new added authorities to search based on reasonable general concern, what does the bill say about oversight of the CBSA officers? Or do we simply have to wait for the independent oversight bill that is expected sometime?
Who else?
It's a good question. It's a paragraph that I had in the speech and I took out because I just wanted to concentrate on the substance of the bill, and the question of oversight of CBSA, which is lacking, wasn't part of the bill. So, that's perhaps a question that could be asked at committee when witnesses come from CBSA, or perhaps Senator Boniface, who might know more about it at third reading. It's a good question, and it's important.
Senator Richards.
Thank you. Thank you very much, Madam Speaker. Senator Wells, would you take a quick question?
I would, Senator Richards.
I'm just wondering about a reasonable indicator, and would you have any idea of what that might be? It's a very subjective thing by border guards, and running into them in Norway and Spain, I know what it can be like. And sometimes they're not very subjective. So what would be a reasonable indicator in your mind in Canada?
Senator Wells.
Senator Richards, I wish I knew. I know in Senator Boniface's second reading speech last Thursday, she said, these officers are professionals. They've got experience. They know how to pick up cues. I have no experience. I don't know how to pick up these cues. And you might have someone who hasn't shaved in 3 days, hasn't had a shower in 4 days, doesn't dress well, and they could be fine, upstanding citizens having a bad week. Or you could have members of the clergy coming through with their collars on, or you could have fine, upstanding, apparently well-shaven and well-bathed people that come in that could have the worst kind of stuff on their devices. I don't know. There are professionals that do know. I'm not one of them.